Hi everyone, my name is Gabriela Urizar and I'm an immigration attorney at Manifest Law with almost a decade of experience. And I'm happy to be back and welcome. Happy New Year. We have a few questions that were previously submitted, so we'll try to get through them. But we also have some questions on the comments. Please, if you have a question, write it in the comment and I will do my best to provide an answer. So let's get started. So the first question we have here is, what is the typical processing time that you're observing for NIW's I-140s standard petitions, non-premium? USCIS is just increasing the processing time on their website from 11 to 17 months to now 20 months. So I think something to remember and to keep in mind is that the timelines that are provided on their USCIS processing times on the website are usually USCIS telling you that they resolve 80% of their cases within this time frame. So they could answer your case, like give you a response within a shorter period of time, right? But most of their cases are adjudicated within this time frame. Something to also keep in mind is that you're not really permitted or allowed to follow up with USCIS about your case unless your case is out of processing times. And when they take into account what processing times are, they go back and they look at what they're posting on the website. Now, in terms of processing times, what I tell people, especially if they're considering filing for payment processing, is that if they don't have an urgency, they have good underlying status, they're not maxing out on the H-1B, so they don't really need that I-140 approval, to wait, to just be patient and wait, because upgrading your I-140 petition doesn't do anything for the visa bulletin. Your priority date is what dictates when you can go ahead and apply for adjustment of status and a work permit based on that pending adjustment of status application. So just to keep that in mind if you're deciding whether or not to upgrade your petition and pay the almost $3,000 fee. So let's move to the next question. What changes are expected in the EB1 and EB2 NIW rules criteria? As I heard, those are also under investigation. Will that impact pending petitions as well? So at the moment, what we know from immigration, especially with the recent proclamations and guidance from the Department of State and USCIS and the president, is that they are requiring further and deeper background checks for all petitions for people who were born in a list of countries that the US deems as high risk. This doesn't mean denial of the petitions, but it will likely create a backlog and take a longer time to adjudicate these petitions, right? And now, in terms of the scrutiny for the EB1 and EB2 NIW, nothing has come up in terms of guidance from the government for this type of applications. NIWs are facing a higher scrutiny level right now, and we're seeing a higher denial rate and also a higher RFE, request for additional evidence rate, but they're still getting approved, right? And if you have the right strategy and you're able to provide an application that's very well documented and very well organized, you have really good chances of getting it approved. Now, why are we seeing an increase in denials for the NIWs? If you look historically, all of this data is online at USCIS website. Historically, you see it from the past few years, there was a huge spike in NIW's applications, especially from these very large IT companies that were just filing NIWs for people that didn't really qualify, just very generic applications. So of course the demand was higher, and then USCIS caught up on this and started being a little bit more strict on the applications and requiring the applications to be less generic. So most attorneys, immigration attorneys, are reporting that the denials and the requests for evidence that they're seeing for both an EB1 and EB2 NIW applications are when applicants are very generic, or when they just put a bunch of information and it's not well organized. Remember, you have to make the application as easy as possible for an officer to approve. If you get a petition that's all over the place and very disorganized and hard to follow, it is not very likely that an officer is going to issue an approval right off the bat, right? So just keep those things in mind. But they're getting approved. They're still getting approved. The EB1 has really high approval rates. So if you're thinking about this, definitely worth exploring. Okay, let's move to the next question. Which is a better option? EB2 PERM or EB3 PERM directly from TN versus H-1B from TN, then EB2, EB3. So something to keep in mind is that the TN doesn't have dual intent. TN is a non-immigrant intent. So when you apply for a TN, you're making the attestation that you don't have the wish to live and work in the US permanently, right? So sure, if you come with a TN, you're here over 3 months, your intent can totally change. And there are ways to get around that. Again, I highly recommend you speak with an attorney before doing this, but there are ways to get around it. Now, in terms of what is a better option, to do the EB2 PERM directly from the TN or H-1B from TN. H-1B will be the better approach because H-1B is a dual intent visa. So if you're able to get the H-1B, that would be a great option for you. And something that I tell my clients is that think about timing, right? The PERM application, just the process, even before filing with immigration, just the process of working with the Department of Labor and getting the labor certification could take up to 2 years. So you could have a strategy where you are under a TN, you start your PERM process right away, that's working in the background. Now you apply for the lottery. Let's say you don't get selected, that's fine, right? Because in the background, you have this PERM application pending. That doesn't mean that you have applied for immigration benefits, right? You're still at the Department of Labor stage. So that is a good strategy to have that in the background, the PERM, and then try to apply to an H-1B because the H-1B will give you better flexibility. You know, you're able to travel in and out of the country while your immigrant application is pending because of the dual intent. The TN doesn't allow this. You have to stay grounded in the US until you're able to apply for adjustment of status, which is the green card application, and get a travel document, which could take up to a year or even longer. Okay, let's move to the next question. So if you can elaborate a little bit on your question, you just wrote Canadian citizen, pharmacist on TN. So we're going to come back to this question if you're able to provide a little bit more background on what your question is. Again, for this one, I need a little bit more background information about what you're asking. That would be very helpful. So let's move to the next one. Can one file an H-1B amendment extension based on a minor salary annual increase more than 6 months before the H-1B renewal date to leapfrog any upcoming H-1B wage policy impacts? This is a good question that a lot of people are asking. In terms of this, I would say be very careful because USCIS is expecting for people to try to use this strategy to circumvent the new H-1B wage policy. So it could be dangerous, right? An amendment, especially for an H-1B, is only required when there is a material change. A minor salary increase is not considered to be a material change. So just keep that in mind in terms of strategy. So let's move to the next question. Any idea on what is the status of the H-1B wage increase proposal that asks to increase the minimum wage for existing H-1B holders? So it is my understanding that this has already passed. It was proposed, but the rule passed. And now it will apply in the next lottery. I am currently an asylum seeker and waiting for court. So I know that by law, it's possible to apply for EB1 or EB2 NIW. question is, how hard can it be to do adjustment of status? So the thing with, you can totally file for the I-140 based on the EB-1 or EB-2 NIW. The thing with work visas and adjustment of status is that they're way more strict than, let's say, asylum or family-based applications. So it will depend, right? Like, if likely you will need to depart and apply for the green card abroad. It really, this is a very complex question, and it will really depend on the facts of the case. If you enter lawfully into the US, if you enter with a visa, have you accumulated any unlawful status? So it will really depend. And again, I recommend to schedule a consultation with one of our immigration attorneys, and we'll provide a link in the comments. We're giving a discount for people who are watching the webinar. My salary currently falls in wage level 3 according to the OFLC website, but last year my colleague H-1B got picked up and his LCA says wage 2. Is the new H-1B system, under the new H-1B system, will I be filed in 2 or 3? So that depends totally on your application, right? If by next year, I mean this year, I'm sorry, if by this year when the application's open, let's say you're selected and invited to apply, you have to look at the salary for the area where you're going to be working for this year. So that will depend on that. It will depend on your the requirements that the job is requiring in terms of educational credentials. So it will totally depend on, it's very specific. And again, based on that, then you will know if you have to file under level 2 or level 3. My date is current EB3 2013 and done with medical RFE. My daughter is turning 21 in June 2026. How to expedite my case? So if your priority date is current under EB3, I'm thinking that you already filed for an I-485 application, and since your daughter is a minor, she already was included in the application. So as long as she's able to apply for adjustment of status prior to turning 21, they should likely be safe to stay within the family application. What is the minimum number of hours that can be specified in concurrent H-1B petitions? The second employment can vary from 2 hours to 10 hours depending upon the project. So this is a very specific question. I highly recommend that you reach out to one of our attorneys to have a talk, because you have to look at the fact of whether are you talking about an H-1B cap exempt, doing concurrent with another H-1B, or 2 H-1Bs subject to the cap. So it really depends. This is very case specific. So if you can reach out to one of our attorneys and schedule a consultation, that would be very helpful. How responsive Manifest is in responding to queries from clients. So that's something that Manifest prides themselves in, is being extremely responsive within 24 hours to 48 hours to clients, because we do understand that's one of the biggest frustrations within the immigration legal field, that clients, especially now that there's so many immigration updates and immigration attorneys are very, very busy. That's one of the biggest complaints that we hear from clients who leave the firms that they're working with and then come to us, that they want a response, right? Like they want a response quickly, especially if they have an emergency. So that's something that we prioritize at Manifest, to provide relatively quick answers. Hello, I have a question. Can professors and specialist doctors from Iran apply for the EB-1 and EB-2 programs? Thank you. So for filing for the I-140 based on either EB-1 or EB-2 NIW, likely yes. Remember that the EB-1 category not only has the green card based on extraordinary abilities, but they also have the category for outstanding researchers and professors, So if that's something that you fall into, that would be a good way to explore getting an I-140. Now for the EB-2 NIW, you have to show that your work is going to be of national interest for the US. And in terms of specialist doctors, you have a strong point for you, because we know that there is such a shortage of physicians in the United States, especially specialists, right? So if you're able to, let's say, identify an area either by specialty or by geographical area that has a huge and critical need for physicians that do what you do, that would be a great way. Just keep in mind, though, especially if you're out of the US, that some countries were put on a list where they're not getting adjudications for immigration benefits. So if you can go to the list and take a look to see what country are there, to make sure that Iran is not one of them. I am on an H-1B up to renewal in September of 2026. Employer company being acquired next year. So will it be an H-1B transfer or an H-1B amendment case? So usually when you have a company that's acquiring your company, or right, so it will likely be an amendment just to show the material change, especially if there are going to be changes in your salary or the position that you're doing. But USCIS is very well knowledgeable about acquisitions, and from the experience that I have in terms of doing cases like this, the applications are pretty straightforward. They likely get approved, and you shouldn't really see an issue. And when you file for the amendment, you can file for an extension at the same time. My STEM OPT got denied due to CIP issues on January 5th, 2026. My initial OPT is expiring on January 5th, 2026. Based on my designated official suggestion, I reapply STEM OPT on January 5th. So this is a very specific question. I highly recommend that you speak to an immigration attorney and that you speak to your DSO, because usually when people get a denial, it is recommended that they wait at least 30 to 60 days to, we call it a cool-off period. But I understand that you're in a situation where your status is gonna expire soon, or it has already expired yesterday. So I will be very mindful of that, because you don't want to run into a situation where you are accumulating unlawful status, or USCIS deems that you are not complying with your visa. I believe we answered a question for you, but this is a little bit different. I have a PhD in civil engineering and a CEO of an engineering company with 15 years of experience and a strong resume. I would like to apply for the EB-1 or EB-2. Again, it will depend, right? If the work that you're doing is going to benefit of the national interest of the US, then the EB-2 will likely be a better fit. But if you're able to show that you are a trusted expert in your field and that you're at the top of your field, you have publications, you have letters of recommendations, your work has been featured, you have reviewed the work of others, your work has been published in journals, then the EB-1 is a better fit. So EB-1 is usually for people who have more credentials and more visibility into their work, but the work doesn't necessarily need to benefit the US. And then the EB-2 national interest waiver is for people who are doing work that benefits the United States national interest, but you don't really have to have publications and you don't really have to have visibility into the work that you're doing. Okay, let's move to the next one. Okay, now 180 days automatic work extension apply to the reapplication, and I can continue work from when the grace period, 60 days. So this one is very specific. I will definitely recommend that you reach out to speak to one of our attorneys, because as we know, the automatic extensions for most of the visas was eliminated recently and doesn't apply anymore. So definitely reach out to make sure that you don't fall under those categories. Is the U.S. consulate going to reschedule any further visa appointments in India for H-1B visa appointments? So we don't know the answer for this. What we have seen is that people who had visa appointments in India in December and early January got pushed out all the way until July. Some people are reporting even further, but I personally don't know of any cases that were pushed even further. I know of cases that were pushed to like April, May, June. So this was done because the officers didn't have the ability to keep all of the visa appointments that they had and also apply the extra scrutiny of reviewing people's social media accounts and everything else, right? So just be mindful of that. If you are in the US and you're thinking of traveling back home to get a visa stamp, I will say if you can, basically aim towards scheduling your visa appointment towards the second half of this year. I'm on an H-1B since the last 8 years with an I-140 approved. Can I file a concurrent H-1B for a part-time job, 10 hours per week to earn extra money? So it is very important that you speak to an immigration attorney in terms of what are the possibilities of filing an H-1B. You could explore doing a cap exempt as well based on maybe the employment if the employer qualifies. But again, it will really depend on the facts of the case because it's very specific. Is the U.S. consulate in India opening any interview appointments in early February? So we don't have any guidance on this right now in terms of what are they doing. They are trying to handle all of the backlog and delays that they have because they had to push out all of the H-1Bs and H-4 visa interviews because of the guidance from the government of the social media scrutiny. So we don't have any insight on this. If you are in the US, like I previously said, try to schedule your visa appointment towards the second half of the year. What will be a good time? Say, right, what will be a good time to go for first-time H-1B stamping at the end of this year, given all the uncertainties? Again, it is recommended that you usually peak towards the second half of this year, and also if you can, try to stay away from like December where you have all the holidays, because that's when most people who have an H-1B travel back to India to get a visa stamping. So maybe September, October will be a good time to schedule your visa appointment. I have completed my master's degree in the US and graduated in May 2024. My H-1B got picked in March 2023 through company A, but I opted for consular processing. Should I pay the 100,000 fee for change of status? So if you are in the US right now and you will be filing for an H-1B change of employer amendment, likely your H-1B will not be subject to the $100,000 fee because you are physically present in the US and you're filing for a change of status, which is one of the exceptions that the government provided when they provided more guidance on what, the $100,000 fee. If for some reason USCIS approves that new H-1B change of employer as consular processing, then the $100,000 fee will likely apply. When this happens, when there is an issue with maybe maintaining lawful status, or if they want to do a deeper background check, but very unlikely. So if you are here in the US and you're applying for a change of status, very, very unlikely that it will apply. So I don't think it will apply. What are the options available for me considering first STEM application denied and reapplication in the process? I think I previously touched on this one, that it depends on the specifics of your case. If you have already run out of status, usually we recommend people to try to wait 30 to 60 days for the cool-off period to really break down the denial and see why USCIS is denying the application. Has something changed? Are you going to be working at a different job? So it really depends on the specifics of your case. I heard criteria is going to change for EB1A from March 2026. Is NIW and EB1A the same? For the change of criteria, it is very unlikely to happen because the criteria is established by law. So if you go to the regulations or to the Immigration and Nationality Act, you'll see that the criteria is established there. So it will likely require some rulemaking. So I don't think it's very likely that it will happen. I personally haven't heard anything about it. Let's look at this question right now. Does immigrant intent comes only when submitting an I-140 or when submitting PERM? This is a really good question because people are usually confused, right? In terms of when am I applying for an immigrant visa? When you are applying for PERM, all the way until even after when you're applying for PERM, technically you're not applying for an immigrant visa, right? Because it hasn't reached USCIS. So let's say you apply for PERM and you submitted the application with the Department of Labor. And now you're answering questions by immigration and it asks if you ever filed for an immigrant visa. Your answer will likely say no, because you haven't filed for an I-140. The I-140 is the immigrant visa. So that's when the intent kicks in. Like if you file the actual I-140, which is the immigrant visa, that's when you're saying that you have an intent to permanently live in the US. So likely not when it comes to PERM. I have an approved H-1B, but I can't adjust my status from F-1 to H-1 due to a pending H-1 waiver, government funding. Okay, only 2 weeks in. What are my approval chances for a waiver on the no objection grounds? Again, this is a very complex question, so I think it is very important that you speak to an immigration attorney because waivers can be very complex and fact specific. In the new H-1B system, the selection is purely based on salary or any other factors play a role. So it's not based on salary, it's based on wage level. So for example, you could have the same salary that your friend has, right? But you work in different cities. So for example, let's say you make 100K, but you live in New York. And then your friend makes 100K, but they live in Minnesota. They'll probably fall into a higher wage level because of the salary that's required in Minnesota. The requirement is lower, right? So he will likely be deemed as a higher earner, even though you make the exact same number. And you are in a city that's very expensive, New York, so you might likely fall under a lower salary wage. So in terms of the lottery, starting for the new H-1B system, what matters is the wage level. On STEM OPT with a cap exempt H-1B option, planning India travel in March 2026. Should I travel before or after H-1B approval? Safer to delay until I return. Sir, okay. So you're currently on OPT with a cap exempt option. So it is likely safer for you to wait until that H-1B gets approved. Just keep in mind, though, that you will need an H-1B visa stamp to be able to come back into the country after you change the status to H-1B. I saw you have 99% rate for the EB1A. I like your responses, and I'm already with manifests recently. You probably say I met. Is there any possibility? Just wondering that I can show my case to you for EB1A. So when you request a consultation, you're welcome to list my name for that you want to speak to me as an attorney. I do have 10 years of experience and I've done a lot of EB1As and I do actually like them. I'm actually passionate about this type of visas because I like to get creative and I love to see the results in approval. So yeah, you can totally mention my name when you are asking for a consultation. As a Nigerian, can I file for the EB1A? Nigeria is currently on the partial ban list. So something to keep in mind, and this goes for everyone who is on the list. Filing is allowed. And I highly recommend filing. Filing will give you a priority date that will put you ahead in line. A lot of people are making the wrong decision of saying, oh, I'm not even going to file because my country is on the list. They're creating a further delay that doesn't have to happen. What the guidance from immigration is saying is that if you're on the list, then they cannot adjudicate your petition, right? Like they cannot give you an approval, but they can still process it. You can still file. You can still get a priority date. So if you're able to file, I will highly recommend that you file the I-140 so that you can secure that earlier priority date. So we answered this question already, so let's try to move on to the next one. I applied for an F-1 in October 2025, and I did not get any approval notice yet. This is for my son. He's still on an H-4, and by April 2026, he will be 21. Go to USCIS website and check out if F-1 is one of the applications that are permitted to apply for an expedited decision. Because if an F-1 is one of the visas that you're able to apply for expedited decision, we have actually just recently created a guide on how to apply for an expedited decision, and I think this could qualify on the grounds that, it will likely impact your son both career-wise, because he will not be able to continue his education, but also financially. So that could be a good option. If you go to our website and then you go to resources, you will be able to find the guide that we have there. Does immigrant intent comes only when submitting the I-140 or when submitting PERM? If it is from I-140, can I renew TN on expiration November 26 after PERM application? So, like I previously mentioned, intent really comes into play after filing the I-140. If you're on the process of the PERM application with the Department of Labor, you're not applying for an immigrant visa. You're just testing the market. You're not even testing the market. Your employer, this application doesn't even belong to you. It belongs to your employer. Your employer is testing the market with the Department of Labor to ensure that the labor market is protected, right? So technically, you could have a TN while the PERM application is running on the side. Remember, it takes about 2 years to get that labor certification approved. So if you're able to get on the PERM and start working on that, I highly recommend doing that. But then when it comes to the applying for an H-1B, parallel to that, I will recommend as well apply for an H-1B to be able to have the dual intent visa, so that when you file the I-140, you have no issues with traveling. You can come in and out because the H-1B has dual intent. How can I check if the proposed endeavor that I'm thinking for my EB2 NIW is good enough? What can I do early in the process to have a solid profile and application? This is a great question, and just the fact that you're asking puts you miles ahead of other people. People think that they need to ask themselves this question when they're like a week away from filing. A lot of the cases that I see that have the strongest applications is for clients that have started thinking about applying from when they were students, right? Because you can proactively build your profile while you're in school or even early in your career, so that when you're ready to apply for one of these applications, you have a solid profile, right? Like in the decisions that you're making, in terms of the jobs that you're taking. Now, in terms of where you stand right now, based on your credentials, it is very important that you schedule a consultation with one of our attorneys. And that when you schedule the appointment, that you provide as much detailed information ahead of time. Because, for example, when calls are scheduled with me, I like to have all the materials ahead of time, go over them, create a strategy plan, so that when I have that half an hour with my client, I don't like to waste it in reading through the credentials, right? Like I already read through it, I have a plan of approach, and I can advise my client, and I can utilize those 30 minutes just on pure legal strategy and guidance. So schedule a consultation and speak to one of our attorneys so that they take a very tailored and specific look on your case. We also have different plans where we provide tailored approach for people, like guidance for people to build their portfolio before they're even thinking about applying. So that's another option that we can provide you with. As the H-1B lottery process is changing this year, TN at the border with CBP versus USCIS for H-1B stamping in Canada. So I'm assuming you have a Canadian citizenship. So the thing with USCIS versus CBP in terms of TN, it all depends on your goals and the strategy, right? USCIS is more consistent. They're more consistent in terms of adjudication. They have policy memos, guidance that they have to follow. So you have a better understanding whether or not it will get approved. You don't have to leave the US. You can just stay here, file the change of status or extension here in the US. So there is more uniformity, right? However, the scrutiny is a little bit higher and the likelihood for a request for evidence is a little bit higher and it takes longer. Obviously, if you pay for payment processing, it's more expensive. You have to pay for the fees. Now, CBP. CBP is way faster. You literally just show up to a port of entry, either CBP at the airport or at a land port of entry. But and I think people don't understand this, but CBP officers have huge discretion when it comes to approving or denying your application. We've literally have gotten reports from clients who are like, immigration attorneys in general, who are like, this port of entry, the approval rate is like 30%. And then people go to another port of entry with the same application and they get approved. So officers have full discretion. They don't have to follow guidance. And they could likely deny you, but you're saving, if you have a strong petition, if you are confident in your application, then CBP will be recommended because you're saving a lot of money on fees and it's faster. The next question that we have here is for EB-1B petitions, outstanding researcher, profile, working in the US since the last 18 years in pharmaceutical research. How many expert letters are recommended? So for this type of application, I will likely recommend 5 to 8 expert letters and to keep them, to have a diverse pool of recommenders, right? So if you can have like university professors, like CEOs of like nonprofits, maybe doctors at hospitals or, C-level executives of pharmaceutical companies, to have a diverse pool, right? Have a diverse pool. And something that I recommend generally is for clients to, when they approach a professional, to let them know that they will provide as much guidance, because a lot of these people are very busy. So if you ask them to write your recommendation letter, that could take a very long time. They're more likely to say no. But if you have everything ready, your information, the work that you've done, the impact, and even do maybe a pre-drafted letter, they're more inclined to say yes. From my experience, the letters that I see that USCIS gives more weight to are the ones that are independent recommenders. The ones that come from people that have directly worked with you, direct managers or co-workers, usually don't have as much credibility. So if you have good connections, especially in the field that you haven't directly worked with, like direct manager or co-worker, those will be great recommenders for you. How long is taking on average to get a receipt notice for AOS and the Texas Service Center? It really depends on the officer of the case. We're seeing people get receipt notices that are taking up to a month, or even with charging fees. Usually, I will say like a year ago or 2 years ago, attorneys will see the deduction on the credit card or debit card of the fees like within 48 hours. Now it's taking like 2 weeks for USCIS to even deduct that payment. So just keep that in mind. It is taking a little bit longer. You are allowed to follow up with USCIS, but only after 30 days after the submission of the case. I am physically present in the US, graduating in 2024. The H-1B that was picked in 2025 under Consular was not approved or not yet approved. Should I file for processing, change of status amendment with the new employer? So if you're physically in the US and you have status, you can likely file a change of amendment, but just keep in mind that the last decision prevails. So if this one gets approved quicker, I will say withdraw the prior one as soon as you get this approval. Because if the old one gets approved after the new one, then the old one will prevail. So just keep that in mind in terms of strategy and timing. Is it safer to travel to India while on STEM OPT status or go on H-1B approved status? I would say likely it is better to have an H-1B approval first and then travel outside to get your visa stamping. Because when you have STEM OPT, like you get into the whole thing of having to have a valid offer of employment, have visa stamp, timely perfectly, very case specific, very specific to the facts and very tailored. So if you have an option to have the H-1B approval first and then schedule a visa appointment based on the H-1B, that is a stronger option. So approval rates you mentioned are first-time approval or approval after RFEs. So in terms of the approvals for the firm, it is my understanding that the approvals are pulled together, meaning that they're also taking into account RFEs because the cases are approved. If you're talking about USCIS approval rates, you can actually go to USCIS website. They have a very good chart where they show you the percentage of cases that are approved without an RFE, the cases that are denied, and the cases that are approved after an RFE. So we answered this question already, so we're gonna move on to the next question. Does speaking in conference helps for the EB1A and also a pending patent? It definitely helps, but it's not the only evidence you need to provide, right? Like you need to show that overall you're a trusted expert in your field. So, and also the patent falls into the prompt that you show that you have made original contributions to your field. So one pending patent, it's not enough, but it could be a piece to the puzzle, right? Now, speaking in conferences helps because, again, it's showing that people are engaging you. They're asking you to speak in conferences because they trust you. You're a trusted expert. But again, just one conference and one pending patent wouldn't be enough. Like I will definitely build on that. Why do most founders apply for the O1A instead of the AB1A when the criteria is almost the same for AB1A? This is a great question, and I'm glad you asked because people usually confuse this type of visas, right? Remember, the O1 is a temporary work visa with non-immigrant intent, but the criteria is a little bit lower than the AB1. The AB1A, they have almost identical requirements, but because you're asking for an actual green card, the scrutiny is higher and the level that you have to achieve is higher. So a very usual path is for founders to come to the US with an O1, work on building their profile like a year or two, and then utilizing all of the evidence that I use for the O1, plus the additional work that they've done in the last 1 to 2 years, and then apply for the green card. And that's a very streamlined path, high likely for approval, and that a lot of people do. But that's why they do that, because applying for a green card off the bat, like the AB1A, you have to have a very high standard or have won a very grand international award like a Nobel. Can you elaborate on why original contribution for EB1A is difficult these days? Yes, because people are very generic and very broad. I actually personally, this is my favorite prompt because I think that you can argue anything, but you have to provide evidence. You have to stay within your field of expertise, and you have to also show that how this is linked to all of the work that you're providing. So the reason why this is becoming difficult is that people are not using this criteria correctly, and they're being too broad. They're not providing actual examples on how they're contributing to their field. So we have about 10 minutes and we're going to take a few more questions, okay? Hello there. I was in the US for 18 months on my H-1B for my employer and returned to India last month. Can I switch my employer, still use the remaining days on an H-1B if they do transfer my visa? So if your employment ended and you return to India, then you will likely need to file a new H-1B amendment, right? Showing that the employer wants to rehire you. Also keep in mind that this will likely trigger the $100,000 fee because since you're outside, it will likely require consular processing. If you have a visa stamp, it could change a few things. So this is one of the cases that I also recommend you scheduling a consultation with an attorney so that they can actually take a look at all the specific facts of your case. So I'm physically present in the US, graduated in May. So we answered this question, so we're gonna move on to another one. And we're uploading a recording of this webinar into our YouTube page in case someone joined late and was not able to see the answer of their question. Is it possible to move from E3 to an EB1A? So the E3 is a non-immigrant intent visa. So the intent comes into play. Again, this one is one of the type of visas that I recommend you speak to an immigration attorney because you have to have a good strategy so that you don't have an issue with the intent. Does moving from a TN to H-1B incur a $100,000 fee? If you are physically in the US and you are filing for a change of status here in the US and USCIS approves the new H-1B as a change of status, then the $100,000 fee will not apply. Graduated in May 2024 from a US university. The H-1B that was picked in 2005 under consular processing has not yet been approved. Should I file for permanent processing now or wait? So this was answered already, but I'm gonna quickly answer it again. If you are able to file an amendment change of employer, I would likely recommend you apply for permanent processing because you want that decision to come before the first application. Because if you have the other petition come after this one, if it gets approved after this one, then the last action of USCIS prevails. So I think we are good for now in terms of questions. I hope this was helpful for you guys. And just keep an eye out because we're going to be doing more of these questions. Again, please, if you have any question, you're welcome to reach out to us either at our website or you can reach out to our social media. Our attorneys are very engaged in our social media, so we're answering questions constantly. Thank you, everyone.